Hello, my name is Erin Elliott. I'm the managing attorney for Elliott Immigration Law, and today I'm going to give you a brief summary of H-1B visa issuance restrictions per Presidential Proclamation 10052. So this is the proclamation that was signed by President Trump in June of 2020, and it expanded the previous proclamation and extended the date. So the proclamation is effective until December 31st, 2020, and can be extended after that. And it applies to both immigrant visas and non-immigrant, but today I'm just going to talk about the application to H-1B visa issuance. The plain language of the proclamation states that it only applies for H-1B applicants who are outside of the country on the date that the proclamation was signed. However, based on recent DOS guidance, we know that really it's being interpreted to mean that if you were in the U.S. on the date the proclamation was signed, but you later leave for visa stamping, you too will be subject to the suspension by the proclamation. So in order to overcome that suspension, there are several listed national interest exceptions, and these were really spelled out by Department of State in more detail. So once you've determined that you are subject to the proclamation, you next want to see if you meet one of the national interest exceptions. You only have to meet one exception. Some are pretty straightforward and others are a little bit more complex. So for those that are straightforward, I'll just briefly tell you what they are. The first is if you are a public health or healthcare professional or researcher coming to the U.S. to alleviate the effects of COVID. The second is travel supported by a request from a U.S. government agency or entity to meet critical foreign policy objectives or to satisfy treaty or contractual obligations. The third, which I think more applicants will meet this exception, is travel by an applicant seeking to resume ongoing employment with the same employer in the same position in the same visa status. So for H-1Bs, this means you are already an H-1B holder, you're just doing an extension of your H-1B, you're with the same company, the same position. The fourth requirement for the national interest exception is a little bit more complex, so I'm just going to break this down. It states that the exception is met if it's travel by a technical specialist, a senior level manager, and other workers whose travel is necessary to facilitate the immediate and continued economic recovery of the U.S. DOS has clarified that in order to meet this exception, you have to meet 2 out of 5 sub-requirements. The first of those is 1, continued need for the position. DOS also clarified that the best way to show this is an LCA that was certified July 2020 or after. Although if it was certified before, you can still meet the exception. What's important though to meet this exception is that the employee has to be required to perform those duties in the U.S. So if there are duties that the employee can perform outside of the U.S., you wouldn't meet that first requirement. The second possibility is that the job duties are significant and unique contributions to an employer meeting a critical infrastructure need. So this can kind of be broken down into 2 parts too. So 1, the H-1B applicant is either a senior level employee or an employee that's providing significant and unique contributions. The second part of that requirement is that the employer, or really the customer of the employer, falls under a critical infrastructure sector. And I would say that the work that the H-1B applicant is doing is related to that. So you really need to meet those 2 elements to satisfy this one particular requirement. The third possibility is that the wage exceeds the prevailing wage rate by at least 15%. The fourth is that the H-1B applicant has unusual expertise in a specialty occupation. And the fifth is that the denial of the H-1B visa will cause financial hardship to the employer. Thank you so much for listening. I hope that gave you a little bit more guidance on issuance of H-1B visas. I understand that this is ever changing, and you want to make sure that you have the most recent guidance from DOS and USCIS. So if you have more questions, please call our office at 404-890-0372. Have a great day.